Welcome to this explainer. If you've ever found yourself staring at a tricky statutory interpretation question, just wondering how on earth to bridge the gap between static, ancient legal language and dynamic social welfare, well, you are exactly in the right place. Today, we're giving you the definitive, high-yield playbook for mastering the Mischief Rule for your legal exams. We are going to focus on exactly how you can demonstrate to your examiners that you understand this rule not just as some dry theory, but as a seriously powerful corrective mechanism used by judges when literalism completely fails. We're going to structure our analysis today exactly how you should structure your exam essay. We'll move from beyond the literal skin to origins in Hayden's case, the four-step framework, modern guardrails, and wrap up with winning case law examples. All right, let's jump right into section 1, beyond the literal skin. Let's start with your ultimate exam hook. You always want to explain to your examiner the stark contrast between standard interpretation and the Mischief Rule. So while the literal rule prioritizes the strict dictionary definition, focusing merely on the words or the skin of a statute, and the Golden Rule modifies that literal meaning just to avoid sheer absurdity, the Mischief Rule goes way deeper. It acts as a powerful corrective mechanism that dives into the true spirit of the law. It completely bypasses the surface text and focuses directly on the actual social problem that the statute was meant to fix. Now, this is also known as purposive construction, and you absolutely need to use that specific terminology in your exam answers. Examiners are actively looking for that clear connection between the historical Mischief Rule and the modern purposive approach. Basically, you deploy this rule when the material words of a statute are ambiguous and can literally have multiple meanings. So instead of judges just throwing their hands up, this rule lets the court select the interpretation that actively identifies and eliminates the mischief. It's all about pinpointing that underlying legislative intent. Moving on to Section 2, Origins, specifically Hayden's case from 1584. Examiners love historical authority, and for the Mischief Rule, your absolute starting point has to be Hayden's case. You don't need to give a massive history lesson in your exam, but a quick mention of the facts proves you really know your stuff. So, the facts involve King Henry VIII dissolving religious houses and transferring their land and rents over to the Crown. Now, the Crown included a protection clause allowing any grant made 1 year before the act to continue as a life estate, but new leases made while an existing estate was already in place, those were going to be voided. Why? To stop something called the doubling of estates. This created a massive legal conflict on a very specific parcel of land between a copyhold granted to a man named Ware and an 80-year lease subsequently granted to a guy named Hayden. To break that down a bit, in the earlier years, Ottery College, which was a religious institution, granted a copyhold to Ware's father and son for life. Later on, right before the dissolution, they granted an 80-year lease to Hayden on that exact same land. So in 1584, the court had to step in and decide if this amounted to the prohibited doubling of the estate. Essentially, people were trying to double dip on land estates to secure their wealth before the king took over, and the Crown wanted to shut that down fast. To prevent this very specific mischief, the court used this brand new rule to determine that Ware's copyhold was in substance an estate for life within the meaning of the statute, meaning Hayden was completely ineligible for his 80-year lease claim. Boom, the double-dipping mischief was suppressed.
All right, Section 3, the four-step exam framework.
Now we get to the absolute heart of your exam answer, the core diagnostic framework laid down by Lord Coke in that 1584 ruling. The crucial point here is that you must memorize and apply these exact 4 questions in your essay. First question, what was the common law or existing legal position before the making of the act? Second, what was the mischief and defect for which the old law did not provide? Third, what remedy has Parliament appointed to cure the disease of the Commonwealth? And fourth, what is the true reason for that remedy? Walking your examiner step by step through these 4 questions shows a highly structured, methodical approach to statutory interpretation. By answering those 4 questions, we arrive at this pretty incredible directive. Lord Coke explicitly stated that the office of all judges is always to make such construction as shall suppress the mischief and advance the remedy. What this actually means is that judges aren't supposed to just be passive readers of text. They have an active, commanding duty to ensure their interpretation actively defeats the harm the law was enacted to stop. They have to solve the legislative intent and prevent any subtle inventions or evasions for private gain. As noted much later in the 1898 case in re Mayfair Property Company, applying this framework ensures judges are actually adding force and life to the remedy for the public welfare. Or, if you want to sound incredibly smart in your exam, pro bono publico. Seriously, this is a brilliant A-grade tip. Explicitly highlight that the mischief rule is ultimately a tool of public good. Dropping that Latin phrase into your essay will absolutely make it stand out.
Next up, Section 4, Modern Expansion and Guardrails.
Now, to secure those top marks, you can't just live in the year 1584. You need to show your examiner how this historic rule operates today, along with its strict judicial boundaries. Let's fast forward a bit. Lord Reed beautifully modernized and expanded the definition of mischief. He stated that it includes any unsatisfactory state of affairs disclosed by facts presumed to be known to Parliament when the bill was being considered. This is fantastic for bringing in contemporary examples. Think about how modern courts use this flexibility to interpret evolving technology, like taking an old privacy law and applying it to a brand new AI tool. By recognizing the unsatisfactory state of affairs Parliament originally intended to fix, the rule continuously adapts to modern times. However, this is where the best students truly separate themselves from the pack. You must include the guardrails. A strong exam answer always acknowledges the intense tension between the separation of powers and a judge's duty to achieve justice. Let's be real, the mischief rule has faced valid criticism for giving judges way too much power to essentially rewrite the law from the bench. So you must cite the crucial guardrail established in CITV Saw the Davy. The mischief rule is a secondary canon. If the words of a statute are plain and susceptible to only one meaning, this rule steps back and gives way to the plain meaning rule. A judge must never use the mischief rule to do violence to plain language or rewrite a perfectly clear statute. Finally, Section 5, Winning Case Law Examples. Look, an exam answer is literally nothing without case law proof. So let's rapidly fire through 3 distinct examples of the rule in action so you have plenty of ammunition for your essays. Notice how incredibly flexible this tool is across completely different areas of law. In Smith v. Hughes from 1960, the Street Offenses Act prohibited soliciting in a street. The defendants thought they found a clever little loophole by tapping on windows from balconies, since technically they weren't standing down in the street. But the court used the mischief rule to shut that down immediately. The actual mischief was the harassment of passersby, so balconies were included to advance the remedy. Then, in RMDC v. Union of India in 1957, interpreting the Prize Competition Act, the Supreme Court looked at the legislative history and narrowed a really broad definition to specifically target the evils of gambling, not just all competitions of skill. And in Bengal Immunity Co. in 1955, the rule was used to interpret Constitutional Article 286, curing the massive economic mischief of multiple provincial taxes hitting a single interstate sale. So that's 3 different statutes, 3 different problems, all solved with one consistent purpose of approach. So let's wrap this all up. You now have the clear definition, the history of Hayden's case, the strict 4-step framework, the modern boundaries, and the practical case law to back every single bit of it up. Remember, the mischief rule isn't just about reading words on a page, it's about solving real problems and advancing the remedy for the public good. Armed with this structured approach, how will you investigate the true spirit of the law to advocate for the public welfare in your own upcoming exams? Keep this framework in your back pocket, apply the true spirit of the law, and I know you'll absolutely ace it. Thanks for joining me on this explainer, and happy studying.